welcome to this webinar on lawmaking in illiberal regimes, or regimes with illiberal tendencies, which slightly expands the canvas, which is being co-convened by the Bingham Centre for the Rule of Law and the journal The Theory and Practice of Legislation, formerly known as Legisprudence. My name is Murray Hunt, and I'm the director of the Bingham Centre, where I work very closely with one of the editors of the journal, Dr. Ronan Cormacaine, who leads the Bingham Centre's work monitoring UK legislation for compatibility with rule of law standards. I'm also the UK's alternative member of the Council of Europe's Commission for Democracy Through Law, otherwise known as the Venice Commission. And in that capacity, I can testify to the importance and the topicality of the subject matter of today's webinar. The Venice Commission has been paying increasingly close attention to the quality of lawmaking in its opinions on draft laws, and it recently published a compilation of relevant opinions and reports on lawmaking procedures and the quality of law, which is a very useful resource for those of you who haven't yet come across it. And at its most recent session, just earlier this month, it again commented on deficiencies in the lawmaking process in relation to a number of countries, for example, in relation to the fast-tracked Turkish legislation on the prevention of financing of the proliferation of WMD. The OSCE's Office for Democratic Institutions and Human Rights has also been doing superb work on this important subject. And Ronan and I have been very pleased to be working closely with Cote, head of the Legislative Support Unit at ODIHR, from whom you will be hearing later on, as part of a group of experts developing some draft guidance on good democratic lawmaking. So it's a great pleasure for the Bingham Centre today to be co-convening this event with the journal The Theory and Practice of Legislation. You can read fuller versions of the presentations being given today in the latest issue of the journal. I'm really sorry I'm not going to be able to join you for the rest of the webinar, but I wish you all a very successful afternoon's discussion. And I'll now hand over to Ronan, who will be co-moderating the event, along with Professor Dr. Timea Dranoci from Hungary. Thank you all very much indeed again for coming, and have a very good afternoon.
Thank you, Murray, for those kind words, and thank you also for hosting us at this webinar today. A couple of housekeeping points just to start. We will shortly be hearing from our speakers, and I'm really pleased with the breadth of knowledge and experience and coverage that we have in our speakers today. The speakers will be talking for between half an hour and 3/4 of an hour, and then we will have a time for questions afterwards. I think we can all get the most value out of these kind of events if you want to engage and give feedback to the speakers. So I would ask you, if you use the question and answer function on Zoom, to type in your questions, and whenever we finish the talks, then myself or Timea will ask the questions on your behalf. So as soon as you've got a question, please type it in to the question function, and I think you can upvote questions if you think they're particularly important. I'm going to introduce our first two speakers. First of all, we have Cote, who is the head of the Legislative Support Unit at the Office for Democratic Institutions and Human Rights, which is part of the OSCE. That's all a bit of a mouthful, but I'm sure Cote will be able to go through exactly what that role is. Very happy to have you here today, Cote. And may I also introduce Professor Dr. Timea Dranoci from University of Pécs in Hungary, and also the Federal University of Minas Gerais in Brazil. And I'm going to apologize now for getting the pronunciations of all those things completely wrong, but I am doing my best. And it's Timea who has done most of the work in putting together this special issue of the Theory and Practice legislation, and she's done a huge amount of work on illiberal regimes, lawmaking, constitutional decay. So we're very happy indeed to have her there, to have her here today. And without more further ado, then I will pass over to Constantine, who will give us a bit of an introduction to the work of ODIHR. Over to you. Thank you.
Many thanks to you, and thank you for the kind words, Murray. Indeed, first of all, I would like to sincerely thank all of you for allowing me to take part in this and to share the platform. It's a great pleasure to join you and to say a few words on behalf of the OSCE Office for Democratic Institutions and Human Rights, as well as to provide some highlights to our work on legislative assistance, and in particular on the issues related to the lawmaking. I would also like to emphasize on extremely and mention extremely fruitful cooperation we developed with between ODIHR and Bingham Centre for the Rule of Law, we've done a few interesting projects looking together into the various aspects of what we call democratic lawmaking or a good lawmaking, and I'm pretty sure that there will be more activities. There are more activities ahead. Let me start probably with an obvious assertion that the ways in which legislation is made profoundly impacts everyday life of each of and every of us. And this gives us indeed a ground to be concerned, not only with the final product, which is the law, in terms of its compliance, for instance, with the human rights norms, but also with the process itself. And partially this is because the deficiencies of the process may lead and frequently do lead to the poor quality legislation, but also because the process is important in itself, respecting the transparency, inclusiveness, principle of rule of law, democracy in the process of lawmaking have a potential to define societal attitudes, influence the credibility of the process, whether and to what extent the laws are accepted by societies, and to what extent different segments of society have a chance to be involved and to be heard. And this inter alia contributes to the security of a state. And as you know, the OSCE is a security organization, but it places the human rights, principles of rule of law and democracy in the center of a broader concept of the security, in parallel or together with the traditional concept of a military security. And that's why we're looking so closely into the human rights issues, into the rule of law related issues, and these are the commitments actually the state made as a participating state of the OSCE, undertook the commitments to implement we call them human dimension commitment within the OSCE region. These are the human rights related issues, but they go beyond human rights and they encompass and cover the rule of law related principles, the principles of democracy. They look into the need to establish sound and strong democratic institutions, and so on and so forth, and as well as, of course, to implement all other international obligations which states willingly undertook. And in this process, ODIHR was established. Well, actually, participating states established and equipped ODIHR with a mandate to assist them in implementing the human dimension commitments. And there are a variety of ways in which our institution helps the states, and legislative assistance is only one of such possibilities. And already since 2004, we offer legislative reviews to the participating states based on the request we receive from the public institutions. We offer legal opinions, legal analysis. And Mari mentioned Venice Commission. We frequently do this analysis jointly with the Venice Commission on especially in certain areas. And I myself, I'm former substitute member of the Venice Commission many years ago. So I had a pleasure to work on that side as well. And so we do the legal reviews jointly, and indeed in these legal reviews we pay more and more attention to the issue of the lawmaking while reviewing the legislation, and I'll touch on that a little bit later. There have been hundreds of legal opinions produced since 2004, and in the process of the legal analysis, we have also noticed that there was a clear connection between the quality of the legislation and the legislative process. And therefore, already in 2005, 2007, ODIHR started to offer states a new service line, let me call it, and that way, and that is a comprehensive assessment of the legislative process. So we're looking at the various aspects of lawmaking cycle, the various stages of a lawmaking cycle, starting with the legislative planning, developing policy options, public consultations, law drafting, etc., throughout the option and monitoring and evaluation as well, which is frequently a weakest part of the chain of the lawmaking. I would say in many states they do not have an efficient or effective mechanisms of monitoring and evaluation, which leads to the wrong policy decisions. States are engaging into the legislative drafting while there is not really a need to do that, but that's a different story. And during this assessment, we have observed similarities, similar deficiencies, if I may so, in the process of lawmaking across different states, and that led us to the next stage of developing, brought us to encouraged us to start thinking about developing the guidelines democratic lawmaking. And this is something we again we closely cooperate here with Savina, with Ronan, and of course with Mari. The guidelines which will be looking again, which will be offering the recommendations, the advices to the policymakers, or not only policymakers, to everybody who is involved or interested in this subject, including to the stakeholders, or including to the civil society who should benefit from the public consultation and be part of the public consultation. So guidelines will cover or will address various aspects of the lawmaking process, advising on the good standards, offering the good standards which are available across the OSCE region, but also building up on the existing international norms, soft law norms, and as you know, there is a developing case law even, which speaks more and more now about the need for a proper, inclusive, transparent lawmaking process. And OSCE commitments are also pretty straightforward in this respect. There is a 1990 Copenhagen document, 1991 Moscow document, which among other, commit states to protect and promote fundamental rights and respect the rule of law during the legislative process. And importantly and interestingly enough, they also commit to ensure the normal functioning of the legislative bodies during the emergency times, to make sure that even during such an extraordinary period, the lawmakers are placed and equipped well in order to make sure that the executive is not overstepping the boundaries and while introducing the legislation which limits the fundamental rights. And we saw, of course, in the context of the pandemic, we saw many attempts many attempts when states rushed the legislation through the parliaments. There were cases even when the parliaments were not even consulted on this process, or did not even have a power to provide effective oversight. Regarding I think I will not take much time. Ron mentioned half an hour, and I certainly was not aiming to speak for such long. It's just a few words to overview our work, but to address probably the main issue, the main question, which is do liberal states show evidence of a particular type of a lawmaking, or do the certain type of lawmaking make it easier for liberal states or tendencies in the governments to achieve their objectives? I think it's I remember here the quote from Anna Karenina, which from Tolstoy, that every family is happy alike, but unhappy in its own way. So I think just to revert that, I think. Yes, we do see the trends which are pretty similar. So every state which had a trend to go to the illiberal direction, let's say, you would that's from the observations which I could afford myself to share with you. You could see that there are certain tools or practices, let's say, which are pretty much common or similar. But having said that, I think that it's not as straightforward as well. I mean, the complexity of the question is that you see similar trends or similar practices also in the states which are liberal or which remain liberal. So it's interesting to see that while in some of the states certain mechanisms are used in order to shift the balance again even further in favor of the executive. Limiting the ability of the society to implement the effective control, you may find the same tools sometimes applied, especially during the emergency times. We saw that applied in other parts of the world, which are not considered, are not really illiberal, and that kind of impacts also the way other states are following the example of these liberal models, considering that also as a good practices, employing these models and then developing them further. So I think with that, I will stop. I would like to thank you once again, and wish you the very interesting discussion. And as Mary, I would need to leave in approximately half an hour, and would like to apologize for that as well. Thank you very much.
Thank you, Kote, so much for your introduction, and it is really great to have you here. And thank you so much, Murray and the Bingham Center for the Rule of Law for hosting us today, and Ronan for everything, organizing this webinar, co-editing the issue, co-authoring the introduction, and talking with me about autocratization and how it could affect lawmaking process. The ongoing autocratization processes in the last couple of years have led us to ask the question of how legislation is actually made in a political and legal environment in which illiberal and populist governments govern and systematically disregard the rule of law, democracy, and relativize human rights protection. Our special issue collects the most prominent examples from Poland, Hungary, Turkey, Brazil, Italy, and Indonesia. Our goal was not to investigate illiberalism as a whole, but instead examine the interrelationship between illiberal tendencies in government and the lawmaking process. Do illiberal states show evidence of a particular type of lawmaking process? Or do certain types of lawmaking process make it easier to have illiberal tendencies in government? I hope that we will have some answers to these questions after the presentations of our speakers today. And all of you are invited to read the articles in the next volume of the Theory and Practice of Legislation. Let me now introduce our speakers. Agnieszka Bienka-Cala is a professor at the Faculty of Law of Nicolaus Copernicus University in Torun, Poland. Viktor Zoltán Kazai is a PhD candidate at the Department of Legal Studies, Central European University, Vienna, Austria. Valentina Rita Scotti, who is a postdoctoral research fellow, School of Law, Koç University, Istanbul, Turkey. Thomas Bustamante and Emilio Meyer are professors at the Law School of Federal University of Minas Gerais, Brazil. Giovanni Piccirilli is an assistant professor at Luis University of Rome, Italy, and Saru Arifin, a PhD student at the Faculty of Law, University of Pécs, Hungary. Thank you so much again for accepting our invitations. I'm very much looking forward to your presentations and the discussion. And so, Agnieszka, the floor is yours.
Thank you very much, Tina, for the floor. And first of all, I would like to thank you very much, Tima and Ron, legislation in Poland, and to participate in this workshop. I am really honored to be here today among such prominent scholars and prominent audience, and look forward to discussing the current problems of lawmaking in illiberal regimes. The paper that I am discussing today presents some of the findings of the research titled Illiberal Constitutionalism in Poland and Hungary. The research is conducted together with Tima and is supported by Polish National Science Center. So taking the systemic perspective, I describe the tendencies in legislative practice in Poland since 2015 that are associated with the illiberalization of the constitutional system, and I investigated their role in the deterioration of legislative quality and thus maintenance of the illiberal constitutionalism. These tendencies are, first, the pure majoritarian approach to legislation, second, inequality, third, illiberal content of laws, and fourth, defective constitutional justice and compromised judicial independence. As for the first tendency, a majoritarian vision of a state community is emphasized in the political narratives of the ruling majority, which is transformed into political decision-making and situated against rule of law considerations. In other words, the will of the majority of people is placed above the constitution and its values, and this is reflected in adopted laws. Exactly this tendency may be associated with the Polish version of the rule of law, which we decided to call illiberal legality. The second tendency is connected with the majoritarianism, and this majoritarianism generates inequality, de facto discrimination against a certain group of people, for example, LGBTQI+ community, and de jure inequalities, which can be found in the legislation on retirement age and pension. Within the third tendency, I mentioned two examples of illiberal content of laws. First is ordinary state statutes are used to achieve informal constitutional changes, and this is the consequence of the lack of constitutional majority. And the second is that lots of laws are symbolic. And the fourth tendency is connected with the captured constitutional court that cannot defend the illiberal constitution and safeguard individuals against the state. The Constitutional Tribunal has been empowered as co-creator and a defender of the illiberal system and invisible illiberal constitution. Here we should also consider that the legislative process is accelerated to such an extent that there is no meaningful discussion, consultation, or public participation. The disagreement on moral, for example, abortion, or crucial, like EU membership issues, is closed arbitrarily by the Constitutional Court, who is executing the will of the ruling majority. From the legislative practice perspective, this is the most important and the most dangerous exercise. The shortcomings of legislative process, together with the new role of the Constitutional Tribunal, are the cause of that the link between legislation and people is defective, and thus the democratic character of legislation and lawmaking is degrading. And this is the picture of lawmaking in illiberal Poland. So thank you very much for your attention and pending your questions.
Thank you, Agnieszka, so much for your presentation, and it is a pity that we have only limited time for you to present your paper. And I think that that we can have our questions and comments on lawmaking in illiberal Poland. And now I would like to give the floor to Victor, who will be talking about Hungary. The floor is yours, Victor. Thank you.
Thank you very much. Good afternoon, everyone. Let me say thank you first to the organizers of this event. I'm honored to be here. So I will present my paper, or the main findings of my paper, which is entitled "The Misuse of the Legislative Process as Part of the Illiberal Toolkit, the Case of Hungary." So to give you the context of my main argument, let me just mention very briefly that since the 2010 elections, the Fidesz government has enjoyed a 2/3 parliamentary majority in the unicameral National Assembly in Hungary. So it would be a logical assumption to say that the governing majority would have no problem with implementing its political program in the form of statutory law because it has a qualified majority, a constitutional majority in the parliament. The reality is, however, that the Fidesz government often violated the rules of the legislative process in order to enact a very large number of extremely controversial measures in the face of every opposition as fast as possible. Let me give you one specific example from the field of judicial independence. So the Fidesz government attempted to undermine judicial independence ever since its entry into office in 2010. But let me pick up the line of events in 2016, when the idea of creating a separate administrative court system was first floated. The problem was that in 2016, the Fidesz government temporarily did not have a 2/3 majority in the parliament. The pickle was that the amendment and the amendment of the acts on the judiciary would have required a 2/3 parliamentary majority. Now, what the government did is that they tried to hide these very controversial legislative steps in an ordinary legislative act, and they adopted it in an ordinary, simple legislative process. The most important changes would have been the re-regulation of the competence of the Budapest Metropolitan Court of Appeal to function it in practice as an administrative Supreme Court, and to delegate a couple of politically very sensitive cases to this specific court. Now, this law was challenged before the Constitutional Court, and the Constitutional Court eventually annulled the legislation on the basis that it was not adopted in a special 2/3 majority legislative process. The story did not end here, unfortunately. After the 2018 elections, the Fidesz government returned for a third consecutive mandate with a 2/3 majority again in the National Assembly. And this time they decided to move forward with the reform of the administrative judiciary. This time they decided to not to hide their measures in any way. They clearly established a separate branch of administrative courts and placed it under the direction of a newly established administrative court. The political motives behind this legislation were obvious. Now, despite the fact that they had a 2/3 parliamentary majority, they still decided to resort to a large number of procedural irregularities. So first of all, they adopted this legislative measure as part of an omnibus legislation. So in the very beginning, it was not at all obvious what their reform was about. It required a couple of very talented journalists to figure out what this law was about in practice. Secondly, despite the fact that the government has a very clear and explicit statutory obligation, the government did not have any impact assessment and did not have any preliminary consultation before the introduction of this legislative proposal in the parliament. And thirdly, this law was adopted in a chaotic parliamentary legislative process. The parliamentary opposition tried to block the adoption of this law. And that's why they created some chaos, to be honest, in the National Assembly. But the governing majority decided to move ahead, to move forward in any case. So, for example, the president of the chamber, or the speaker, when he realized that he did not have access to the speaker's podium, he decided to preside, to chair the parliamentary session from the benches. And also the members of parliament were able to cast a vote without inserting their card into the voting machine, which means that the results may have been potentially manipulated. Despite a very large number of quite serious procedural irregularities in 2019, the Constitutional Court declared the law to be constitutional, both in terms of form or in terms of procedure, and both in terms of its substance. So these are the kinds of procedural irregularities that my paper is about. And my argument is actually quite simple. It's really not rocket science. So I start from the definitions of the Council of Europe and the European Union, their definitions of the rule of law. In both definitions, it is clear as day that the enactment of parliamentary legislation in a legally correct manner is a very important element of the rule of law, meaning that if parliamentary legislation is adopted by violating the rules of the legislative process, it constitutes an infringement of the rule of law. Now, as long as these procedural irregularities remain isolated problems, it's not a huge deal, because these kind of procedural irregularities can be witnessed even in so-called healthy or well-functioning democracies. The problem arises when these procedural irregularities become a systemic problem. And if it's a systemic problem, we have to analyze it as part of a rule of law backsliding, which is a common feature of the European illiberal regimes, and Hungary is unfortunately one of them. Now, the contribution of my paper is basically that I looked at all the criticisms of the Council of Europe and the European Union, which actually highlighted these procedural irregularities. And both of these regional mechanisms, they criticized the Hungarian government for having failed to meet the rule of law requirements concerning the parliamentary legislative process. But the problem is that their criticisms remained very sporadic, and their analysis was far from comprehensive. For example, in the 2021 rule of law report of the European Commission, the European Commission does actually note that there are some problems with the parliamentary legislative process in Hungary, but their analysis is very, very far from comprehensive. So my paper wanted to show that the problem is actually much more serious than the EU and the Council of Europe mechanisms think. So that's why I basically analyzed the jurisprudence of the Hungarian Constitutional Court between 2010 and 2019, and I drew a map of all the various types of procedural irregularities litigated before the Constitutional Court. I identified 16 different types of procedural irregularities. The most typical ones are the lack of preliminary consultation, the lack of impact assessment, the introduction of major legislative reforms in the form of a private member's bill in order to circumvent the rules on the adequate preparation of bills, the complete revision of legislative proposals by last-minute amendments, the use of accelerated procedures without any good justification whatsoever, and the violation of the qualified majority requirement, unfortunately, quite often. So that was my summary of the paper. I hope I give a very good presentation of my main findings, but I'm happy to answer all the questions that you have. Thank you very much.
Thank you, Victor. I think that you picked just the perfect example when you were talking about the administrative court reform. So the perfect example of how none of the standards of democratic lawmaking has been observed in Hungary. So thank you so much. It was really great. And now I think that we are, yes, sorry. So who is next, please? I think that it would be Valentina from Turkey. Yes, sorry. I was like listening to Victor and trying to find the best concluding sentences, so I forgot to check on my job. Sorry for that. Valentina, the floor is yours.
Thank you very much. And first of all, let me join my colleagues in thanking you and all the other organizers for having me here. It's a pleasure and an honor to join this group of scholars today. What I will try to do in the time I have is to focus my intervention on the main results of the paper I have presented, which is about the effectiveness of the regulatory impact assessment in Turkey with regard to the norms concerning gender equality. So preliminary, I need to underscore that the Turkish constitution currently into force has been approved in 1982, and it has established a legal system aimed at ensuring state efficiency and, I would say, stability, political and economic stability, more than the full respect of the rule of law. The Islamic populism that arose in the last decade under the AKP regime has built on this approach of the constitution, its system for keeping the power, which is mainly based on reinterpretation of the fundamental concepts of constitutional democracy in order to entrench a paternalistic majoritarian vision of the lawmaking process, and I would say overall of the society. So when it comes to the principle of gender equality, this means that on the one side, we see a confirmation of the denial of the rights of the LGBTQI+ community. And on the other side, we observe an interpretation of the principle of gender equality, increasingly in line with the Islamic conception of gender complementarity. And this limitation of women's enjoyment of equality is quite striking if we consider that Turkey is a country that has started the process of emancipation and empowerment of women at the beginning of the 20th century, coevally with the establishment of the Republic, as well as if we consider that in 2009, Turkey has established a committee, a parliamentary committee on equal opportunity for women and men, the CEFEC, with the exact aim of ensuring gender impact assessment throughout the lawmaking process. So it has introduced in its legal system a tool that is comparable to the best practice of the at the European level, which exists, for instance, also in Sweden. Indeed, when we compare the formal adhesion of Turkish rules to the European standard on regulatory impact assessment and moreover on gender impact assessment to the other cases that we can find on the European continent, we observe that formally there is an overall compliance. But in fact, in practice, we see that these assessment procedures fails to be inclusive and evidence-based, and that they are mostly conceived as time costing and I would say useless formal exercise. Therefore, when we analyze the activity of the CEFEC, we see that there is a huge amount of provisions that may impact on gender equality, but are approved without realizing the gender impact assessment. Furthermore, when we consider the case of Turkey, we see that unfortunately, in line with other European countries where right-wing populism have taken the power, religion is increasingly exploited in order to entrench gender complementarity so that women can find protection for their rights only when they accept to be conceived as members of families and not as individuals. So they don't have rights by their own, they have rights only as mothers, as wife, and so on and so forth. And this is evident also by looking to simple examples such as the denominations of laws or ministries in Turkey. For instance, we have seen in 2011 an important change in the denomination of the Minister for Women Affairs that turned to be the Minister for Social and Family Affairs. So women disappeared because they are part of the family. The same is for the law that was approved in order to comply with the Istanbul Convention that at the beginning was the law for the protection of women from violence and then became the law for the protection of women from violence and the protection of the family. So again, this element that comes back. So in brief, just for concluding, in the article, I try to demonstrate that the rise of Islamic populism has transformed the available tools for gender equality protection already existing in Turkey in mere reputational tools to be showed when the country is accused of ignoring this fundamental principle of contemporary constitutionalism, and that the more bodies and policies include the word family in their denomination, the more the attention to women's rights disappears in favor of women's marginalization and gender complementarity. complementarity. So therefore, I used a quotation from Shakespeare in order to say that with another name, the rose is not a rose anymore. When introducing family, the protection of gender equality changes completely its interpretation. I think it's better if I stop here, and I'm ready to answer all the questions you may have. Thank you very much for your attention.
Thank you so much, Valentina. Listening to you, when it comes to gender issues, I almost feel like home. Unfortunately, thank you so much. And now I would like to give the floor to Thomas, who will talk about the Brazilian situation. Thank you.
Thank you very much, Timia. It's an honor to be here. I would like to thank for the invitation for this panel and for the opportunity to hear you all speak of a very important topic. Our paper tries to answer an interesting question on whether or not presidential systems are better positioned than parliamentary systems to resist illiberalism, especially Brazil, because if you just look at the institutional setting and the institutional design of Brazil, you will see that we have a very fragmented political system. We have more than 30 parties represented in the House of Representatives. So we tend to have very fragmented governments. So in order for the president to be able to perform her duties, she must compromise to form a very large majority. Never in the Brazilian history since the redemocratization, a president was elected with more than 15% of the seats in the House. So the only way to get majority is to make large alliances, most of them after the election results are disclosed. So this is the question that we intended to answer. And we looked at the first 18 months of Bolsonaro's term in order to try to assess whether this was the case or not. So this was the question, and I think that given the importance of the roles played by the National Congress in any government, we expected that the Congress would be able to contain some of Bolsonaro's illiberal proposals and to change the whole ethics and the whole legal system of Brazil, to turn Brazil from a fairly liberal democracy into an illiberal and authoritarian system. So that was the question, and I think that there are some institutional incentives for Brazil. So before we answer this, let's try to speak about the rule of law. What we want something to think something very simple about the rule of law is the idea that the rule of law only works when there are a set of commitments that to the rule of law. There's no rule of law without fidelity to the rule of law, without an ethos in which people regard themselves as mutually accountable to the law. If the law is to rule, that means that the law alone will rule. We will not be subject to the arbitrary will of a single individual. So Bolsonaro attacks this principle because it is antithetical to his project of governance, his idea of good governance. And how does he attack it? I think that he is distinctively illiberal in the sense that appears in the contemporary literature, because it is not only populist, it's anti-enlightenment, in the sense that it attacks the rationality of the rule of law. The law only works if all of the legal norms work together, if they form a system and an intelligible orientation which we can use to guide ourselves. But what Bolsonaro does is to turn one norm against the other, to systemically disobey the law, to challenge the law and to sabotage the law in order to undermine the ethos that we need for the law to rule. And he does it systemically. He does it when he decides who to appoint as a judge, who to appoint as the rector in a university, who to appoint in the agency that is in charge of the protection of the Amazon or to protect the indigenous populations who live there. or even the environmental agencies. Okay, so this is his method. So he tries to undermine the rule of law indirectly by undermining not the large principles at once, but the very concrete legal rules. Okay, so how can the legislature resist? It is not very easy to resist because the legislative responses are very slow. It takes a while for a legislature to pass a statute, to pass an act, to approve, or to turn something into the law. But we have experienced some successful experiences in the first 18 months of Bolsonaro's term, especially when Rodrigo Maia was the chairman of the House of Representatives. We were able to contain some of Bolsonaro's authoritarian impulses, especially in criminal law. He wanted to change criminal law to turn it into a very strict law and order system in which people in which policemen could shoot people without being punished. So this was contained. Another thing, some of the efforts to undermine university academic freedom, for instance, and freedom of press, these things were barred in the legislature. Okay, so the response was quite liberal when it comes to the morals. Okay, but by the same token, the legislature fully endorsed Bolsonaro's economic plan. So by endorsing Bolsonaro's economic plan, this created another paradox because it made Bolsonaro stronger before the pandemic. Okay, so we were able to cut some of his illiberal laws, but given the full economic support or the agenda of reforming the pension schemes, the labor laws, the tax system, these kind of things, Bolsonaro was able to retain some of his power. Then the pandemic broke, and what happened is that in the beginning of the pandemic, we thought that the clash between Bolsonaro and the legislature would become stronger because Bolsonaro's negationism, his denial of the pandemic, his reluctance to give social aid to the poor people who lost their jobs to the pandemic, his attempt to concentrate unlimited temporary legislative powers in himself, all of these things, these attempts failed. So we expected that the pandemic could bring some kind of shock to reality and contain Bolsonaro. But what happened is that Bolsonaro moved to the center, and there was the midterm elections for the chairman of the houses, and Bolsonaro was able to gain the chairman of the two houses. So the legislature became more conservative than the previous one. Okay, so now we have this kind of impasse in which there are hundreds of impeachment requests, but none of them gets processed because the chairman of the lower house doesn't give weight to it, doesn't actually decide on anything. Bolsonaro managed to put his allies in the key positions in the two houses, but nonetheless, given the fact that there is a judicial decision authorizing the minority of the upper house, the Senate, to initiate a parliamentary commission inquiry, we now have an inquiry commission to render Bolsonaro accountable for the wrongs that he committed during the pandemic. So his popularity is getting lower, and we expect that some results will be achievable because of this inquiry commission. I'm happy to talk about the findings of such commission later, but I think that I'm running out of time now. Thank you very much. I would like to give just 1 or 2 minutes for Emilio to conclude. Thank you very much.
Okay, just quickly. Actually, I think that we could add some other comments and analysis. I think the most important thing that we should debate on our discussion and the Q&A is the configuration of what we call here in Brazil the coalitional system of presidency. This is the most important thing that we should debate to understand how this system was developed in the presidential configuration and how it can respond to Bolsonaro's authoritarian practices. But thank you to you all.
Thank you, Thomas and Emilio. And I think that what Thomas was describing as anti-enlightenment is very interesting thought. And I think that he also described this quasi-resistance in the legislative power in Brazil, which is also very interesting, especially when we want to compare it with some European systems. Thank you so much for these. And now I think that Giovanni would like to share his findings about Italy. Thank you.
Thank you, Tinea, and thank you all. Sorry if my connection is not the best. I had some connection issues at home, and I had to steal the connection from a public place. So I also the audio connection will be good. And please let me take just a second to say that I'm very happy to share this presentation with Valentina because we shared important moments in our postdoc in Lewis, and it's a pleasure to be here with her. And yes, I'm sharing my findings on Italy. And if you allow that, it may sound surprising to find Italy that in many places in the literature can be considered a well-consolidated democracy as a regime leaning towards some illiberal tendencies. But as I try to show in my paper, I try to reconstruct the tendency in Italian legislation in the last, I would say, 25 years, also 30 years, and they went hand in hand with the evolution of the political system. And what changed in Italy is, of course, the methods and techniques of lawmaking, but also the political system in a broader sense, the party system. And also, this is important because our democracy that was born right after the Second World War with a particular protection of the autonomy of politics. And especially from the point of view of the Constitutional Court, it was important to not to interfere too much with the autonomous deliberation that was among all the parties, even the Communist Party, that was an important piece of the reborn Italian democracy. But this set of rules and this set of constraints now seems to be weak in a system that is profoundly changed, and also a system that shows a very interesting continuity. Because if we see the methods of legislation from Berlusconi to Prodi to Mario Monti to Giuseppe Conte to Mario Draghi, I would say we couldn't find more different models of political leadership, from technocrats like Monti or Draghi to political leaders with clearly liberal tendencies like Berlusconi. But actually, in parliament, the way to approve laws was close. I would say almost the same in the last 20, 25 years. And it's interesting because we probably are experiencing to be a very good lab of the so-called, at least in the literature of political scientists, what has been labeled that as techno-populism. So forms of populism that goes together with a certain understanding of populism and technocracy together. And it will be a useful key to understand the current Italian situation that probably is not exactly between liberalism and illiberalism. It's more on the democratic scale that we are witnessing something worrying. This continuity that we can find, I would say, clearly from the early 2000s is not actually something to be taken as reassuring. There has been a lot of talk about the Italian five-star movement and also the rise of the League led by Salvini. And I would add the Brothers of Italy, that is an emerging party from the far right that will be probably protagonist in the forthcoming election next year or the year later. And the real novelty is that if we could rely on the stability of the political system and the capacity of dialogue also between very different political parties, from the Christian Democrats to the Communist Party. Now what is changed is the tendency of political party to be anti-pluralist. And in a system that has weak checks and balances outside politics, to have a political scenario dominated by anti-pluralistic parties, it's actually very worrying. We are witnessing now a very shifting moment, and probably actually we will witness a shifting moment in the next few months, because we recently passed, also via a popular referendum, a constitutional amendment to downsize the Italian parliament by 1/3 of its members. And now we are slowly working on setting up the new parliamentary standing orders, and might be a new electoral law, and might be further constitutional amendments in the next few months that will probably reshape the form of Italian representative democracy. And this will be a key moment to understand what will be of Italian democracy, and I would say also of Italian lawmaking, because of course, to modify the structure of a parliament with such an important constitutional amendment, we will have a Senate directly elected of 200 members, which is actually a small chamber compared to at least to our habits of a big country of 60 and more millions people. So to reshape the way in which that house and also the lower house will function will be the moment in which we could decide where the Italian legislation and the Italian lawmaking will go in the next few years. To conclude, the problem is that these signals of malaise, these signals of illness of Italian lawmaking are so old and so deep that I'm not too optimistic in seeing the next future. And now we are in this exceptional situation of probably all catch-all majorities sustaining the Draghi government. But in the moment in which we will have the election, that will be in 2 years, or probably next year after the election of the President of the Republic, then the future of Italy will be decided. And I would say that these months preparing that election will be a constitutional moment to reshape the representative democracy and the functioning of the Italian parliament. So with serious consequences also on the techniques of lawmaking. Thank you.
Thank you, Giovanni, for your overview of this sick Italian lawmaking, and that it is more like undemocratic than illiberal. And as we could see, there are like the challenges in the political and constitutional system as well in Italy too. Thank you so much. And now we are going to Indonesia and still remain in Europe. I would like to ask Saru to start his presentation. Thank you.
Oh, well, thank you very much, Professor Timia, for inviting me to speak in this distinguished forum. Do you see my screen? But I don't see here. Okay. The technical problem, so I will not show the PowerPoint here. My paper is illiberal tendencies in Indonesian legislation by taking case of the omnibus law. I mean, this is the first omnibus law in the Indonesian legislation history so far on the jobs creation. The idea of making the omnibus law came from the President Joko Widodo, or Jokowi, his known name, when he delivered a speech in the Parliament's inauguration of the 74 Indonesia Independent Day. The second term of presidential mission or ambition is to accelerate the economic growth and social prosperity. But he found in his every opportunity that law becomes the serious obstacle to realize his ambition to call as much as possible the investors to come to Indonesia. Then the president directed the Agrarian and Special Minister Office to compile and review all relevant legislation for the ministerial offices authorities. Then after studying hard all regulations, the ministerial offices found that almost 632 regulations that they think disharmonious and synchronized between one and other, and that is very impossible to harmonize and synchronize them within the nearly time. So then they proposed to the president to adopt the omnibus law model to synchronize all the laws mentioned. Then within not more than 6 months, I think, the Indonesian Parliament, or DPR, passed a massive bill entitled Job Creation on October 6, 2020, and become Act number 12, 2020, by repealing 2 statutes and amending 82 others, and totaled 1,187 pages. And the question is why the government favored to use this kind of omnibus law, because this is the only way, the most effective way how to make his vision or ambition is possible by using the omnibus law. So there are 2 things that I analyze in this case of the omnibus law. The first is making process extremely fast. Normally, let's say one regulation, it takes 1 year fiscal year, I mean, to finish, but sometimes it can be extended into 2 years. Let's say with the 100 article, it takes very long time to finish. But this one with 1,000 more pages, it only 6 months, I think. And the second one, it is not open to the public, even until the omnibus law has been passed by the parliament. The public always demanding to get the draft of the bill, but the government didn't give the draft. So this is quite a problem, I think. So yeah, can we continue, please? The screen. Yes, I studied some media coverage. How was the government alliances or the government's group answer that question, that the public say that this omnibus law is not transparent and people difficult to find the draft? Then the government alliances say that we have actually opened to public. We have actually came to the public, but after I studied some media coverage, they only came to their constituent. Individuals who are not their constituent, such as NGOs and scholars, are excluded from the drafting process. Additionally, as I taught you before, that after the bill is passed, it is difficult for community organization outside the government to obtain access the draft on the law on job creation. So that's why the government ignoring the people participation, the government afraid that the scholar or NGO criticize this kind of omnibus law, then it will not finish in the frame time that the government has been determined. So in this case, I conclude that the government has successfully brought the legislative process into illiberal, because theoretically the government, the President Joko Widodo has been let's say has been elected by 55.50 voters, but he acting like an authoritarian government by ignoring the basic fundamental right of the people to involve in the process of legislation by giving some criticize insight into the draft of any bill that are stated under Article 19.6 Law number 12 of 2011 on the law formation. So that's my point in the article. Thank you, Professor Mia, for your time.
Thank you very much for that, Saru. Very interesting indeed. And I think it's so obvious whenever we hear your talk compared with the other talks, the same themes are coming out. So before I come to our first question, I just want to make a couple of general observations. And the first is on the political ideology. There's not much common political ideology between the different countries that we've heard from today, except for a couple of points. And the first point is on majoritarianism. And this seems to be the idea that if you win an election, even by, Saru mentioned 55%, even if it's just by a little bit, the idea that that entitles you to do whatever you want in charge of the country. And that means that you can discard all the checks and balances in the system. And the other sort of common political ideology seems to be around discrimination. So we've heard from Hungary and Poland on discrimination on LGBT rights. We've heard from Poland and Turkey about discrimination against women. And this seems to be, maybe not in the other countries, but that seems a theme that's emerging. In terms of the lawmaking process then, the same points seem to be coming up. The use of procedural irregularities. A lot of you have mentioned procedural irregularities in the way that the law is being made. Secondly, you're mentioning the use of accelerated procedures. So not the normal process for making law, but some sort of fast track procedure for making law, which seems to be open to abuse. And that seems to be the case certainly in Brazil, in Italy, the use of presidential legislation. Related to that, not an accelerated procedure, but just making legislation really quickly. So we've seen that in the pandemic with coronavirus legislation. Legislation is made very quickly. And the final general point is on the use of omnibus law, which seems to mean a law which does lots and lots and lots of things, all packed into one piece of legislation. And Saru's example from Indonesia of the job creation is a perfect example of that. I'm going to turn to our questions from our audience. And I think I will start with a question from Alan Esdale. And this is for you, Victor. So Victor mentioned a number of deviations from the proper legislative process. Has this adversely affected the quality of the legislation? Accelerated procedures and the lack of discussion can inhibit a government from carefully considering the details of its proposals. Victor, do you have an answer to that?
Thank you very much for the questions. Yes, of course, but let me start by saying that actually Professor Tima Drinotsi is the expert of the quality of legislation. So I hope that she will say something if I forget to mention something important. To start with the obvious, there is absolutely no careful consideration of bills in Hungary. No, at all. So legislation is actually very opportunistic and extremely casuistic, in the sense that apart from a couple of reforms that they actually think through well in advance, in most of the cases, they just adopt legislation to solve political problems or political conflicts of the day. So we have empirical evidence that we can witness an extremely concerning legislative hyperinflation in Hungary when the National Assembly literally adopts hundreds of bills a year. I think the record was somewhere 800 legislative proposals a year. So nobody, even the wisest legislators, can actually adopt good laws in such an environment. And we also have empirical evidence saying that legislative bills recently adopted by the National Assembly have to be amended extremely fast after their adoption to remedy mistakes. And sometimes these mistakes are like, actually they didn't think it through, but very often they have to correct even like minor mistakes because the language, the text of the legislation just doesn't make sense at all. So we have actually a lot of empirical evidence saying that the quality of legislation is deteriorating in Hungary. Laws often do not make sense at all, and yes, it's partly the result of the high number of procedural mistakes in the legislative process. But the other thing that I said is simply that legislation in Hungary has become extremely opportunistic and casuistic, and there is no serious adequate preparation of legislative proposals in most of the cases. You cannot even find these documents. There would be a statutory obligation of the government to actually publish the preparatory materials of legislative proposals, and you can find them nowhere basically. Even if you ask you submit an FOI request to the ministries, they very often just refuse to send the preparatory materials to you.
Thank you, Victor. You just summarized the quality of legislation in Hungary well, so I don't feel to add anything. Thank you. We have another question from Abdurrahman Satrio to Saru. And the question is especially about omnibus legislation. As we could heard from Saru, there is an omnibus legislation activity is going on in Indonesia. So do you think the nature of this type of legislation, omnibus legislation, make it easily to be exploited by any regimes who have an illiberal tendency? So that would be a question to you, Saru.
Yes, absolutely. According to the courts, theoretically, that the omnibus law strategy through the time-honored to legislative process in this area. So all the process, all mechanism in the legislation process has been established by the omnibus law. In the other thing that sometimes omnibus law legislation is pushed by the committees with less check and balances than normal legislation, because you know that with 1,100 more pages, it is impossible for the committee by the committee or the parliament to check all that article by article. It takes a very long time. As I said before, that normally within 100 article, let's say something like that, it took sometimes more than 1 year to finish it. But this is with 1,000 more pages, only finished with, let's say, 6 months. So the omnibus law method is incompatible with the deliberative democracy, which needs openness and input from the public. That the strategy by the government. And one thing that this kind of omnibus law is not known in the law number 12, the year 2011, on the law formation in Indonesia. So that why this can be successfully used by the government, because let's say almost 75% the parliament are the president alliances. So they cannot deny or reject what the president wants. That's my point, Professor Timia. Thank you.
Thank you, Saru. And just following up on that, I think it's absolutely true that if you have a large volume of legislation, it makes it so much more difficult for parliamentarians to scrutinize it. And if you combine a large volume of legislation with running it through the parliament so quickly, it makes it even more difficult to scrutinize it properly, which means that inevitably the quality of that legislation will suffer. I had a question for Agnieszka. Very interesting talk again, but I was just wondering about the checks and balances in the Polish system. Do you think there is a need for additional checks and balances in the system to address this sort of majoritarianism? Could there be more checks and balances in the Senate, for example?
Thank you for this question. As indeed really important issue, but I think that we have a different majority in the Senate. It is not same. It is connected with that with the procedure, with the rules of procedure, the constitutional rules of procedures, and the position of Sejm and Senate. And you can see that in Senate we have some additional elements of proper legislation. So there is a discussion, proper discussion. We have the consultations, and many actors, NGOs and other actors are involved. And obviously it is an important input to quality of legislation, but in relation to people, to those who are interested in what is going on, ongoing legislation process. But if we think about the relation or this relation between Sejm and Senate within the legislative process, we know that Sejm can outvote what Senate is doing. So even if it is different majority, peace and opposition in Senate, frankly speaking, it cannot form proper decision-making process or proper decision, yes, for democratic legislation and lawmaking. Thank you. I hope that I addressed well your question. Thank you.
Thank you, Agnieszka. And just keeping this topic, I would like to ask Giovanni about what is going on with their Senate there, because one of the aim of the Italian bicameralism was to establish two very different chambers, right? And now it is not really, I mean, seems to be the case. Do you think that these changes would increase or decrease the quality of laws in Italy?
I think that we have the opportunity to increase it if we are able to properly amend the parliamentary standing orders, and maybe to have a good also a modification of the electoral law, but especially from the point of view of the selection of candidates rather than of the electoral formula. we are now debating on that. There are some good texts that have been submitted for modification of the rules of procedure, but there is an ongoing debate, but very in the background, about shifting to unicameralism. That would be a major change, also because, as you said, the two chambers were conceived to be different, but now those differences are narrowing. And lastly, a constitutional amendment to equalize the voting age. That's something that I found necessary, and actually even resolving a constitutional problem that we had in the election of the Senate. But there is a growing discussion of if the two chambers are doing the same thing, as mostly they are, why not to shift to unicameralism? I don't think that we have the political strength to make a choice, such a strong choice, and I don't think it's desirable as a perspective for Italian Parliament.
Thank you, Giovanni. I have a question now for Thomas and Emilio, and it's on the nature of the checks and balances in the Brazilian constitutional system. It seems from the outside that it has been under threat for a long time from things like corruption, and there's been lots and lots of historical scandals. But do you think that the checks and balances in Brazil are sufficient? Because it seems from the outside that, surprisingly, they are actually working to correct the populist tendencies of the president. So the different legislatures and the courts are working effectively. Is that a fair assessment?
I would be optimistic if it were not for the fact that Bolsonaro managed to get two people in very important positions. He managed to get the chairman of the lower house, who is the guy who can initiate any impeachment procedure, and he has the discretion to stop and block any request. And he also managed to get control of the prosecutorial office. So who is the head of the national prosecutors, who could prosecute criminally the executive. So he's managing to lock all the exits. But one of the things that was in our paper that we did not show, I can just show you a screen very, very quick, is the fact that the power of the legislature increased. These are the amendments in the budget proposed by the Centrão, by the parliamentarians. Can you see the level of public money that was spent on request of the legislatures, the amendments that they made in the government's budget? This means that the legislators are getting much more money from the budget than before. So they have the power to force the government into a compromise. But still, Bolsonaro is very radical, and his views are terribly anti-Republican and anti-democratic. So there might be a threat, and I'm not sure how strong our institutions are to resist. Maybe I can leave Emilio to say something.
Yes, I think that one first way of controlling Bolsonaro comes from what we try to show in the paper. That was in the sense that the very formation of coalitional presidentialism in Brazil makes that the president is too dependent of what we call here the Centrão, which is a group of political parties that don't have properly an ideology and depend sometimes on corruption schemes, as it happened in the past, or maybe is still happening, but that are very dependent on the way they can control the president. So for the president to have approved any bill that he wants to go in the Chamber of Deputies or in the Senate, he would rely on their support. So Bolsonaro firstly said that he would not trust those kind of deputies and senators, but now he depends a lot on them. And they are the main actor, I believe, now in Brazil to block an impeachment procedure against Bolsonaro. And the second institutional form of control comes from the Federal Supreme Court. It is interesting to observe that the Federal Supreme Court from 2019 on started to control some of Bolsonaro's main authoritarian measures, but they sometimes keep on believing that they can solve problems with Bolsonaro directly and politically instead of deciding procedures that could halt his main authoritarian projects. But I think there is little room for confidence, and the civil society is the main actor for pressing those institutions to avoid that Bolsonaro reach his main objectives.
Thank you, Thomas and Emilio. And now I would like to ask Valentina. So it seems that from the perspective of gender equality in Turkey, the present is quite dark. How do you see its future?
If possible, I can answer that the future is even darker. As probably you know, Turkey has, there is this problem, this institutional problem that I try to underline in the article that is connected to the gender impact assessment, but now we're facing also a problem concerning the legal basis, the legal ground on which norms are approved, because as you know, the Istanbul Convention has been withdrawn. So now we lost also a reference, a parameter to look at when approving laws. And still we have a problem of a political parliamentary majority looking for gender complementarity instead of gender equality. So unless something is going to change in 2023, when next election will take place, I have to say that I'm not optimistic. To be realistic, I'm not optimistic. So that's the situation, unfortunately, right now.
Thank you, Valentina. And that is very depressing, but probably realistic, as you say. A question, Agnieszka has already answered a question in the chat from Peter, but there's another question from Michael for Victor. When the opposition blocks the session of Parliament, is there a justification to have an ad hoc adjustment to the rules of procedure, such as the seating of the chairperson?
Yeah, so I will give you a very lawyer answer. It depends. It depends on many factors that we need to take into consideration. So first of all, I think we need to examine what exactly triggered the opposition's attempt to obstruct the parliamentary legislative process. And in this particular case, I did not mention it in my presentation because I wanted to finish as soon as possible, but the government showed absolutely no willingness to discuss an extremely controversial legislative measure which would have undermined the independence of the judiciary. So let me summarize just very briefly. So in this particular case, the government attempted to weaken the position of the Supreme Court, the Curia, by setting up a rival institution, a Supreme Administrative Court. The law also would have guaranteed that the government, or more precisely, the Minister of Justice, can manipulate the composition of the administrative courts by exercising influence over the selection of judges. And lastly, the law also wanted to extend the jurisdiction of the already pegged administrative judiciary to election disputes. So I think it was a very, very controversial measure, and it was definitely not a good sign that the government, despite the criticisms of NGOs, scholars, the European Union, the Council of Europe, and opposition parties, didn't want to discuss the details of the law at all. Secondly, I think we need to examine whether the opposition had any realistic chance to convince the majority, or at least to meaningfully participate in the legislative process. Now, what we can witness in Hungary is that ever since 2010, the parliamentary opposition has been constantly sidelined by the parliamentary majority. Of course, they are physically in the parliament as a biological decoration, and of course, on paper, they have the rights, but they cannot exercise them in any meaningful way whatsoever. And if they want to spark a debate in the hemicycle, they usually get fined by the speakers. The speaker imposes like thousands of euros on opposition members of the parliament. I would refer to the case of Karácsony versus Hungary, decided by the Grand Chamber of the European Court of Human Rights, to give you a sense of the gravity of this problem. The third question is that, was it absolutely necessary to adopt that particular legislation on that particular day, meaning only a couple of days before Christmas? It really couldn't wait until I don't know, the spring semester or the spring session. And the other question is that, there was absolutely no other solution than violating the rules of the legislative process, so the speaker couldn't just adjourn or postpone, or to take a break and then resume the session a little bit later. And the very last point is that, yes, I understand that obstruction is dangerous, and of course you're absolutely right. But when we are prohibiting obstruction, what exactly are we protecting? We are protecting parliamentary decorum, right? But what is parliamentary decorum is about? It's about meaningful deliberation. It's about the equality of MPs to meaningfully participate in the legislative process. Assisting the government or guaranteeing the rubber stamping function of the National Assembly, I think it's not a constitutional value that we need to protect. So I would take all these considerations into account before I could give you a yes or no question whether a temporary deviation from the normal rules of the legislative process in case of an obstruction is acceptable or not acceptable.
Thank you for that answer, Victor. I think we are just about out of time now, but I think it's a really fascinating chance to hear the different perspectives from all over the globe on how lawmaking works and the different stresses and strains placed upon the lawmaking process by illiberal regimes or regimes with illiberal tendencies. And I found it very interesting, the common threads that we've had coming through about the abuse of the legislative process, fast-tracking rules, discriminating, sidelining, marginalizing. And my final thought, I will pose that as a question, but I won't ask for answers. And my final thought is, should parliaments be part of the process to act against illiberal tendencies, or are they part of the problem in that they support illiberal tendencies in government? And with that hopefully provocative thought, I will finish up now and thank all our participants again, and especially to Maya for organising things. The full copies of the papers will be available on the website of the journal. It might be subscription only for some bits of it, but certainly the abstracts will be available. So thank you again for attending, and goodbye to all.